All right.
A paid up member.
Paid up. So, explain to us the resolution you and the bar have passed on this matter, because we are confused.
The MPP has forced the Ghana Bar Association to pass.
The MPP has forced the Ghana Bar
Association into ridicule and contempt. The MPP has now recruited the Ghana Bar Association onto the side of the party to fight John Dramani Mahama and the NDC and Ghanaians in general on the invocation of Article 146. Mahama has no role in the invocation of 146. What has happened in 146, Article 146, is that citizens of this country petitioned him in accordance with the Constitution, provision of the Constitution, to remove the Chief Justice. And John Dramani Mahama has followed the dictates of the Constitution. The Constitution says he must establish a prima facie case acting in consultation with the Council of State. He has done that. He didn't arrogate to himself the power to determine whether there is a prima facie case. He didn't. And then there is even evidence of how the Council of State went about determining the prima facie case. And then the Council of State, together with the President, moved ahead to establish a committee as consistent with Article 146 of the Constitution. And the Council of State further advised His Excellency the President to suspend the Chief Justice. And the President, by Article 146(10)(a), must act in accordance with the advice of the Council of State. Tell me, what has the President done wrong? What has the President done wrong? That is why there is unanimity in all persons who are looking at what is happening dispassionately, that the President has not breached any of the provisions of the Constitution. The Bar Association even believes that the President has not breached any of the provisions of the Constitution. And I'm referring specifically to the letter that was signed by Efwa Gatti, the President of the Ghana Bar Association, and another person on the processes so far. What has happened is simply that the MPP lawyers within the Ghana Bar Association have taken advantage of the mid-term bar conference to go and capture the conference and get the conference to pass a resolution and embarrass the association. That's what they have done. It's a total embarrassment. And now they are coming out as a noisy Ghana Bar Association.
Noisy Ghana Bar Association.
Noisy, just pure noise. Why? My brother, when Domuluvu was sacked from office, did you hear the Ghana Bar Association? When civil society organizations decided that the act of the President was unconstitutional and went to court, did the Ghana Bar Association make a pronouncement on that? When the court finally, after so many months in delay, finally pronounced that the president's sacking of Dumuluvo was unconstitutional. Did you hear the Ghana Bar Association? Did you hear the Ghana Bar Association? When the president refused to accept the law on family values and moral what, that was passed by Parliament. Did you hear the Ghana Bar Association? Did you hear the Ghana Bar Association? In fact, it's a total embarrassment, catastrophic embarrassment, visited on members of the Ghana Bar Association, of which I am one, by MPP elements within the Ghana Bar Association who have hijacked the Ghana Bar Association to perpetuate this calumny on the people of Ghana. It's totally unacceptable.
Malaji, they explain why they have reached this conclusion. They talk about Article 296 and then exercise of discretion, that the law was not followed. Are you saying they don't have a case there at all?
Oh, that is even making their case worse. There's a decision of the Supreme Court. It's called Ransford France and the Attorney General. It's a recent decision of the Supreme Court. They should go and read that the bar's exposition, opinion on Article 296C. And this is the Ghana Bar Association. They are presumed to know the position of the Supreme Court on Article 296C of the Constitution, because it has been pronounced in court. So that should be a guiding principle until otherwise set aside. It says that, look, it's not all may used in the Constitution that will require the executive or parliament to come out with regulations on how the discretion shall be exercised. That the Bible says that if that were the case, it will lead to a nuclear meltdown. Have you heard the phrase before?
Yes.
Government will simply ground to a halt to suggest that wherever may is used, you have to get Parliament to pass a CI in the Constitution, a CI to regulate how that may, it being permissible and discretionary, how the discretionary is to be exercised. It's a decision of the Supreme Court. Are they saying that they are oblivious to that decision of the Supreme Court? They don't know of that? This can only be motivated by partisan considerations.
Partisan considerations.
To expose the Ghana Bar Association to contempt and ridicule. The MPP lawyers there must be held fully responsible for the opprobrium that is being visited on the Ghana Bar Association.
When you say the MPP lawyers there, are you referring, because there's a council, there are executives of the Ghana Bar Association, exactly which MPP lawyers should be held accountable for this?
The MPP lawyers who marshaled themselves and went there. Starting from the former Attorney General and his two deputies. They must be held responsible. We were talking about state capture. We never knew that when MPP leaves power, they will capture the Ghana Bar Association. This is a capture of the association. Midterm conferences are held by the Ghana Bar Association to talk about matters that have come between the last time that they had the conference and at the time that they are holding the midterm conference. The Ghana Bar Association had by themselves issued a letter acting through the executives, if what that is executive committee, that the processes so far appear to have been followed. So there is process integrity. And so we should continue to watch and monitor the situation and ensure that there are no infractions of the rights of the Chief Justice. 2 days or 3 days before the conference, the Ghana Bar Association released that statement. So what has changed? Tell me what has changed. At the time that the Ghana Bar Association was releasing the statement, the president had already exercised the power to suspend the Chief Justice acting in accordance with the advice of the Council of State under Article 146(10)(a). So what has changed? What has changed?
I see. But like you said, there are MPP members of the bar. You are a typical example of a member of the bar who identifies with the NDC. Question is, should questions not be asked as to why members of the bar who are members of the NDC were also not there to perhaps defend the position that government has taken?
Well, we don't think that we should, and the statement of the Ghana, the resolution, the purported resolution, speaks in terms of that we should desist from making prejudicial comments. The NDC, as a government and a party, believes that the rights of anybody subject to Article 146 of the Constitution must be respected. And that person, any person, judge of the Superior Court of Judicature or chairman of a regional tribunal, must be given all the opportunity to marshal his or her arsenal if a prima facie case has been determined against him or her, to defend himself or herself at the committee established for the purposes of determining whether the petition should be upheld. That's what we believe. We do not think that we must unnecessarily and needlessly interfere in the constitutional process that has spelled out in detail on how to go about removing a Chief Justice or a Justice of the Superior Court of Judicature from office. That's why we never thought that this matter will come up. Because if the NDC were there and all political parties were manifested there, the whole matter will turn into a political debate. And that will be inconsistent with the original ideas of the drafters of the Constitution. And I've always said that history should guide us. In 1969, when the Consultative Assembly was drafting the Constitution, they made allusions to the fact that we should insulate the removal process from partisan political considerations. They cited the American practice and the British practice. In America, a justice of the Superior Court of Judicature is removed by impeachment in Congress. That's the arena of politics. Congress is an arena of politics. In Britain, it is removed by debate in Parliament. And that's an arena of politics. So in 1969, the drafters of the Constitution said, look, we should neither follow the American practice nor the British practice. We should provide for a situation where the president must act with a non-political establishment to determine whether there's a prima facie case. And if there is one, to set up in the 1969, they called it a judicial tribunal to look into the matter. They were keenly aware that if you transport the removal process onto the political process, the country will be divided. So we are keenly aware. As a party government, we are keenly aware. And I've said always, Sana, NDC, since 1992, has never felt the need to recruit the judiciary into its corner to help the party and government to govern the country. That's why NDC has never made attempts to recruit the judiciary as partners in governance. No, we don't do that. We respect the independence of the judiciary. Justice Georgina Wood went to the Supreme Court in 2007 as Chief Justice. Or she was nominated Chief Justice in 2007. Stayed until Kufuor left office. Continued during the time of Professor Atamils and the first time of John Dramani Mahama. And only went on retirement in 2017. NDC did not file or entertain, or there was no petition for her removal. And NDC did not see the need to remove Georgina Wood from office. No. I also say, look at the Supreme Court. NDC as a political party, that's why I'm proud to belong to NDC. I'm a proud member of the party. We believe in the rule of law. We believe that governance does not necessarily mean that everything must be decided in court. That you must use your best endeavors to ensure that there is consensus on how you approach governance of the country. That is why if you look at the constitutional cases that have gone before the Supreme Court, you can count the number of times NDC has gone to the Supreme Court. Even in good times. NDC, we think that governance is a process. In fact, we come into office to govern. MPP come into office to rule. Dr. Obera Samoa made me understand that. When they come into office, they rule us. That's why they can threaten Parliament to cease and desist. We don't do that. When even the Chief Justice asked for 7 days, not based on any law, but on a practice that she herself has evolved in matters where a petition is sent to her for the removal of a justice of a Supreme Court, the president acceded to that and extended even the time that she requested for. She requested for 7 days. The president gave her 10 days. So we have never failed. And that, you can see that I was talking about never seeing the need. We don't see the need to recruit the judiciary on our side for the purposes of government. We respect the independence of that arm of government. That is why, if you look at the cases NDC has taken to court, the most important of the cases was the qualification for registration of a citizen onto the national register for a voter ID card. That was the most important that we sent to the Supreme Court. And so we have never said that, well, because we are in government, the judiciary must be there to give us all the decisions that we want. We have never felt that way.
I see. But why? Because if you essentially said the MPP is using the Ghana Bar Association, then you are suggesting that the MPP is trying to protect the Chief Justice, ensure that the Chief Justice does not go through this process. To what will it benefit them if that happens?
This is a Chief Justice who, in 2023, said that, or is it 2024? It was 2023, said that Nana Addo Dankwa Akufo-Addo is the finest and most distinguished lawyer in Ghana. You remember that?
I do.
And that he's a champion of the rule of law. This is a Chief Justice who did not hide her admiration for Nana Akufo-Addo and the MPP. This is a Chief Justice who was very antagonistic to persons who sought to challenge the authority of the MPP in doing certain things. So, to whom much is given, much is expected. So if the Chief Justice Tokono stood in their corner, they think that they owe her a duty of care. And so that's why they are standing in her corner. In all these discussions, MPP has not hidden their admiration for the Chief Justice, and they have not shied away from publicly defending the Chief Justice. In fact, they are those who have made this process political.
I see. They have made the process political.
Yes. From going to court when there was no case, when the president had not even taken a decision, to restrain the president from acting, even though the Constitution, being the supreme law of this country, spells out the relative powers of the various branches of government and had given the president certain powers under Article 146. They went to court to invoke the inherent jurisdiction of the court to stop the president. It was led by the former Attorney General and the party being an MP, an MPP MP. You heard the press conferences organized by the MPP in Parliament and also at their party headquarters by the minority leader, Afeni Makin. You heard, consequent upon the determination that by the Council of State that there's a prima facie case, haven't you heard commentary by the two deputy attorney generals under the former attorney general? Haven't you heard them? They have sought variously to supplant themselves as the Council of State and determine whether the Council of State had reason to arrive at the decision they did. They have questioned the integrity of the members of the Council of State and have lampooned their decision that there was a prima facie case. I have not yet heard any distinguished person not associated with the MPP speak the way activists and actors within the MPP are speaking in connection with the petition for the removal of the Chief Justice.
Well, let me conclude on this note. One of the things, the demands they are making is the publication of the prima facie determination that was made by the President and the Council of States. In line with law?
In line with their own personal idiosyncratic reasoning. Which law? Ajechum and the Republic should offer guidance. In any case, the Constitution says the processes for the impeachment or removal of the Chief Justice must be in camera. In camera. And it's for good reason. It's for good reason. And I've not seen an amendment of the Constitution which says that the process must be held in public. In camera means in camera. To protect the dignity and sanctity of not only the office of the Chief Justice, but also the person of the Chief Justice. And Ajechum says, the Tabat says in Ajechum, that if that were to be made public, if the processes are to be made public, the Chief Justice would be so damaged that it will be almost impossible to rehabilitate her. So why do we want, as I said, why does the MPP want to suffer the Chief Justice with that level of humiliation and reputational damage. That's a simple concept.
Alaji, thank you. Thank you very much for speaking to us.
You're welcome.
Yeah. Alaji Inusah Fuseini is former Minister, Lands and Natural Resources. Of course, Member of Parliament for Tamale Central, former Minister for Roads and Highways, too. Before we take any further step, I'd like to just share with you one more good news that I've been sharing with